Hey everybody, welcome to my YouTube channel, Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to give you an update on Carrington's case. He's out of New York, William Carrington. This is his case number if you want to look it up. Kings County Supreme Court 11234-2009, Wells Fargo Bank N.A. versus William Carrington. Interesting case, guys. In the docket, you'll find some interesting information here. Let's start with the latest and greatest thing that was filed. The 27th of February. Notice of cross motion to 2724. Yes, they filed a cross motion and also for summary judgment. They got an affirmation in support of plaintiff's cross motion. They got exhibits, the summons, complaint, notice of pendency, and certificate of merit, affidavit of service. They got exhibits for answers and counterclaims that were filed in 2009, reply to the counterclaim. All of these exhibits are the whole case file, the history. And this is all they're doing. They're attaching the history from everything. That's what they do when they file a motion for summary judges. They basically put everything that was filed into their motion. And so let's look. And so here we go. It's still 2/27/24. They got all these exhibits. And then you'll see an affirmation of somebody named Richard Schweiner. And then you'll see exhibits A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P. With P being the notice of default. You'll see a memorandum of law in support. You'll see a statement of material facts, a proposed order, an affidavit. And then you'll see Carrington filed a response on the next day, on the 28th. He filed a opposition. Basically, he filed a, let me show you what he filed. I think I got it right here. He filed what's called Defendant Supplemental Response. Wait a minute, this isn't it. Sorry. He filed this. Defendants replied to plaintiff's cross motion in opposition to summary judgment. Now, we're not going to read the whole thing here right now, guys. It's just a regular opposition to every single point that they made. And you'll see how he objects to each part. And that's part of it, because he has to. He has to reply to everything. And he did. But we got some more interesting information to go over. But I just wanted you to see this so you would understand what's involved. You have to respond to each exhibit and object to each exhibit, and he did that. And he also stated that each exhibit was not prima facie evidence, which is what they need to have standing. And then he talked about FAPA and RPAPL 1501. And FAPA is a time bar thing, where if it's 6 years, then they can't foreclose anymore. And RPAPL 15014 basically states you can have the mortgage expunged or discharged because of the previous, because it's time barred. And then he talked about res judicata and collateral estoppel. And then what I want to go over, though, guys, are these exhibits that they filed. And you'll see on docket 56, 57, 58, 59, it says exhibits E, F, G, and H. This replaces doc 39, inadvertently filed. Note and mortgage, this replaces doc 40, inadvertently filed. Gap mortgage, adjustable rate note, and SEMA, this replaces doc 41, inadvertently filed. Document H, this replaces doc 42, inadvertently filed. Okay, so, and then the last thing on the docket, complete last thing, Supporting papers to motion. Now, Carrington filed this in response to those last 4 that were filed, those last 4 exhibits. And that's what I wanted to go over. This is one of those motions where you almost want to start at the end because it's the best part. But anyway, let's go over this real quick. This is called Defendant Supplemental Response to the Plaintiff's New Exhibits. Comes now, William Carrington pro se files a supplemental response to plaintiff's new exhibits filed on February 29, 2024 as follows. Plaintiff submitted these exhibits on February 29 to replace inadvertently filed exhibits filed on February 27, 2024. These exhibits are Exhibit E, F, G, and H. Now we just went over this, guys, so I won't have to repeat myself. But basically we're going to object to each one of these that they just filed. The corporate resolution, he objects because it's not referenced anywhere on any of those filings. Exhibit F, the note and mortgage. Defendant objects to this document because it's not relevant in this case. The note, Exhibit F, is from 2005 and was paid in full by a refinance. So, really it doesn't even, need to even be mentioned. Doesn't exist anymore. So, we objected to that. Now, Exhibit G, this is where it gets interesting. Exhibit G, Gap Mortgage Consolidated Adjustable Rate Note, SEMA. Defendant has examined this exhibit and found some defects. See page 25, 26, and 27 of 61 of Exhibit G, and you'll see that this note is fatally defective and cannot be used to foreclose on the defendant's home. A very different consolidated adjustable rate note is imaged on Plaintiff's Exhibit 1, Document 17, filed by Plaintiff on February 27, 2024. See pages 19, 20, and 21 of 82 on Exhibit 1. The differences are as follows. Page 25 of Exhibit G note is stamped Exhibit C above, Consolidated Adjustable Rate Note. This is not on page 19 of Exhibit 1. Page 19 of Exhibit 1 has a barcode on it showing just to the right of defendant's address, 497 Macon Street, Brooklyn, New York. The barcode does not exist on Exhibit G. Now, just so you guys know, Exhibit G and Exhibit 1 have the same note on it, or it's supposed to be the same note. I mean, there can only be one promissory note, right? But see, this is where they screwed up. They have 2 different notes on 2 different exhibits, each filed 2 days apart. And the signatures of William Carrington on the notes are different. Okay, and this is where gets interesting. Page 27 of Exhibit G shows a purported signature of Defendant William Carrington. Compare this with the purported note signature on page 21 of Exhibit 1. The signatures do not match at all. A closer inspection of both signatures is hereto attached as Exhibit Z. Defendant vehemently objects to both Exhibit G and Exhibit 1 because there cannot be 2 different promissory notes used as being prima facie evidence. This constitutes fraud on the court. Now, fraud on the court, guys, is very serious. Do you think the judges care, or do you think the attorneys care? Now, I did put on here some case law regarding fraud on the court. And I stated the requisite fraud on the court occurs when it can be demonstrated clearly and convincingly that a party has sentiently set in motion some unconscionable scheme calculated to interfere with judicial system's ability to impartially and adjudicate a matter by improperly influencing the trier of fact or unfairly. The plaintiff's complaint should be dismissed with prejudice for Plaintiff's Exhibit G and Exhibit 1, which are 2 forged promissory notes, and trying to pass them off as copies of originals. This act by either their attorney Robert Park of Hinshaw and Culbertson or their client Wells Fargo N.A. should be considered fraud on the court. Sanctions and dismissal against the guilty party should be mandatory. Now the case law is CDR Krantz's SAS versus Cohen. I suggest you read that if you're interested about fraud on the court, because this is what they all use as a reference. Defendant alleges that Henshaw and Culbertson used the infamous Wells Fargo foreclosure attorney procedures manual to forge the notes, Exhibit G and 1. This manual provides detailed internal procedures to fabricate foreclosure papers on demand. Plaintiff did not respond to the allegations that they used this manual, which is on page 13 of defendant's motion to dismiss. Now the last thing that it's touched on is the pooling and servicing agreement, which basically states, it states a paragraph from what they submitted. And we won't read it too long because it's kind of long, but basically it states, page 26 of Exhibit H states that the trust closing date is May 15, 2007. This means that no loans can enter the trust after May 15, 2007. Defendant argues that neither note, Exhibit G or Exhibit 1, is endorsed in accordance with the PSA. Both purported notes are not endorsed in blank or by any stamp. There are no attached allonges. This by itself is proof that the defendant's loan is not in the Soundview Home Loan Trust. Also, the assignments mortgage, or Exhibit L, are not dated or recorded before the May 15, 2007 deadline, which is more proof that the plaintiff does not own the defendant's loan. The plaintiffs have not cured their lack of standing, nor have not provided prima facie evidence otherwise. The complaint should be dismissed with prejudice and attorneys sanctioned for their misconduct. Let's take a look at that Exhibit Z, shall we? Alright, come on, Exhibit Z. Alright, here it is, guys. This is where they screwed up. Now look at these signatures, guys. You can definitely see they're way different. I mean, anybody can tell they're different. You don't need a handwriting expert for this one to see they're completely different. And so one promissory note has a barcode next to the address, and it has one of these signatures, and the other promissory note has something that says Exhibit C at the top. And so there are two different promissory notes with two different signatures, which is definitely proof of fraud on the court, guys. We always knew they were doing this, and I think he got them red-handed this time. Anyway, if you guys wanted to look through this stuff, it might help your education on how to fight back in court. Again, the case number and the web address. Here we go. iapps.courts.state.ny.us. You can search as a guest. It lets you do that. You just put in his case number, 11234, 2009. And you can look at all these documents, all these exhibits, and get an idea of what is going on with his case. And this is a very important case. If you guys have any questions, leave them in the comment section below. And everybody have a great weekend.